Only the first slide. Now,
Yeah.
okay, I'll just make it into full screen. Just let me know whether you are able to see it. No?
No, it is not. Okay, carry
Okay.
on that.
So I'm on the second slide, which is relating to the history of copyright. So like I said, when you look at the history of copyright, there was always a manual process of copying. So they used to have the scribes, they used to write the copies. And so it was a very tedious kind of process. Now later, then the censorship and control over the scribe also came into be. Then with the advent of technology, you will find that printers and copiers were available in the market, and the printers and the publishers were given a lot of rights. But when the government found that there were like a lot of infringements which are happening and they are misusing the powers which are given to them, there were certain sanctions and restrictions which were placed by the government. Now, Statute of Anne is the first copyright statute, and the Berne Convention is the convention which it talks about the copyright law. And in India, we have the Copyright Act 1957, and we have the amendment rules, which is like in of 2021. Are you able to see the third slide?
Yes.
Okay, thank you. Now, when we look at the copyright, there are certain benefits which are there, which is being granted by the copyright law. So, like any kind of category of IP, always the private right and the public right has to be balanced. Now, the rights, I would call it as a limited monopoly, which is given to the copyright holder for a limited period of time. So, it is not for in perpetuity. It is being given. There is a limited time, and there are certain exclusive rights which are given. So, we always used to call it as a negative right. Negative right is nothing but preventing the copying or the reproduction of the work without the permission. If anybody is unauthorizedly using the work, then we call it as the right which is given to the copyright holder to prevent such acts. Now, when it is given for a limited period of time, the public interest has to be taken into consideration. So the very purpose of giving it for a limited time is that the government wants to encourage the dissemination of the copyrighted works. So as soon as it enters the 60 years time period, then it will be given out to the public so that the public can use it for their own purposes. Now, the basics of copyright is very simple. So here there is no place for the idea. Yes, I understand that idea is something which is the seed. So from the idea, if you are able to express in a particular way, then in such cases you will get the copyright. So for idea per se, you don't get it. Only for the expression of the idea you get the copyright. Now, for the procedure, for the process, if there is any concept, or if there is any principle or discovery, such things are not copyrightable subject matter. Now, so if any kind of concept, if you are able to describe or record it in a descriptive way, or you can give it explanation to it, you can give the illustrations to such ideas, then those illustrations and explanations, if it is original in nature, then the copyright will be vested. Now, in copyright, there is nothing being said wherein it has to be mandatorily registered. So it is the option. So as soon as the work is complete, so if a script writer completes the script, soon after the copyright is vested with him. Now, there is an option which is available to the scriptwriter to go and register the work under the Copyright Office. It is for the sole purpose that it will give him more strength when he has to contest his case in the court of law if there is any kind of infringement which has happened. Now, the basic thing in copyright is the originality. Now, like I said, the idea has to be expressed. Now, the originality of the expression of the idea has to be there. So it has to be originate from the author, and so even if it is not novel, doesn't matter, but the author independently has to invest his creativity and his skill and judgment, and the ideas which are expressed should originate from within himself. Now, in copyright, two similar identical works can coexist, but the only thing is that you have to prove that your work is independent that of the other, and you have created without getting any kind of help from the other identical work which is in existence. So section 13 talks about in which all kind of works the copyright exists. Now, original word, though it is not defined in the act, it is given for the literary, dramatic, musical, and artistic work. Now, you might ask, like, why the originality is not given for the cinematographic and the sound recording. But per se in the act, it is not mentioned. But when you see the judicial the precedents, you will find the court has decided in favor of many of the infringement of cinematographic films, which need to be original. So substantial copying is being done by by the defendant. In such cases, the originality is taken into consideration. Now, so as I said, it should be original expression, then it should be fixed in a tangible medium, then minimal creativity of the author has to be there, and fourthly, it has to be published. Now, fix it in a tangible medium is very easy to understand. That if you are writing any story, it has to be on a piece of paper, or it can be recorded. And in case of any kind of music, then it can be even recorded. The recorded song can be, the sound recording is also possible. So it has to be on a fixed, on a tangible medium. Now, there are many cases which are coming wherein you will find contemporary arts, or say gastronomic kind of arts, wherein you will find the display of the food. So, or say the makeup which is being applied on the face, or in some cases the sand art, or say the ice sculpture for that matter. So always there is a conflict of understanding whether copyright subsists in such kind of work. So ideally, the position is that till the time it is fixed on a tangible medium, you can call there is a copyright. If it is not fixed on a tangible medium, if you see any of the makeup artists who apply and come up with the face makeup, then till the time it is there on the face, it is not a permanent medium. You cannot call the face as a permanent medium, be it the ice sculpture. So once the ice start melting, then there is no medium which is existing. So these are some of the contested areas wherein you will find, yes, it is original. Yes, it is original expression. There is creativity which is being invested by the author. Yes, it is being published so that it is available to the public to make copies or communicate the work to the public, under any licensing agreement or assignment. But if it is not fixed in a tangible medium, then it will be disputable. Now, when you analyze the threshold of creativity or originality, earlier, always the courts used to look at only the intellectual skill and judgment which is being invested by the author. Later, the judgments were given more importance to the modicum of creativity. That means there should be a creativity standard also for the in order to prove the originality of the work. Now in India, we have we are in between. I would say that in Indian courts, we decide the cases based on if the work is having a skill judge, the judgment and the effort which has been put forward by the author, along with the minimal creativity which has been put in, then in such cases we call it as a creative work. Now, there is a doctrine which is there. We call it as the merger doctrine. That means there will be certain cases wherein the idea and the expression, you cannot separate it. It is merged to such an extent that you are not able to distinguish which is the idea, which is the expression, and there will be very less kind of expressions which are possible. So in kinds of merger doctrine also, the creativity and the originality part is very difficult to make out, and copyright will not be able to sustain. There are two kinds of rights which are given to the the copyright holder. One is the economic rights, and one we call it as the author special rights. So economic rights is nothing but wherein you have the exclusive right to reproduce now in any medium, and you can offer it for sale, you can give it on hire, and any kind of economic rights which is given to the literary, dramatic, musical, or be it the artistic work, or be it in the cinematographic film even, and sound recordings, we call it as the economic rights. Now, the second kind of category of work, which is, rights which are given to the copyright holder, is the moral rights. Now, moral rights is something in our Copyright Act, we use a term author special rights. Now, it is independent as that of the copyright, and even the more economic rights can be transferred, like by way of licensing or assignment. But in case of the moral rights, even after the work is being assigned partly or fully to someone else, the moral rights still vest with the author. Now, there are a few things you have to keep in mind. In moral rights, the paternity right is very, very important, wherein if I'm a sculptor, then I have the right to claim authorship of my work. That is my work. Now, then if I am the author of the work, I have the right to restrain. I have the right to claim damages if I find my work is distorted, my work is mutilated, or my work is modified to such an extent that, it is affecting my honor and reputation of the work. Now, the very important case, as you all will be knowing, is about Amarnath Sehgal versus Union of India. So he is a well-known sculptor, and he was being commissioned to, to create a mural for the government, and it was supposed to be displayed in the Vidhan Sabha. Now, later, Amarnath Sehgal found that the sculptor which was commissioned and which was handed over to the government, it was laying in a store, untouched, and when during the inspection they could find that the sculpture was like mutilated, so a lot of damage had happened to the sculptor. Now, the government argued in this case, saying that, see, it is a commission work, we had given due consideration, so it is up to us to decide like how it has to be used. But the court has come to the rescue of the plaintiff, which is the Amarnath Sehgal, who's the sculptor, and said that, the sculptor has got the moral rights. So even if there is a transfer of the economic rights, the author's special rights or the moral rights will vest with him, and the destruction which has been caused by, keeping it away and keeping it in a closed room has taken at all, and has provided many of the prejudicial to the author. So section 2D talks about the author, the definition of author. For literary and dramatic work, we call the copyright holder as the author. In case of musical work, we call it as composer. In case of artistic work, other than photograph, the artist. In case of a person who takes the photograph, the person taking the photograph, then if for cinematography, film, or sound recording, it's the producer. Now, earlier in the copyright bill, there was a attempt to include even the director as the author of the work. Now, we have to understand that producer is the one who is taking the whole responsibility, right? Even he is ready to take all the economic risk, and the financial investment is being made by the producer. So taking into consideration all these factors, the producer is termed as the author of the cinematographic film. But yes, the film is like, an amalgamation, or you can say that there are it's a collaborative process wherein you will find copyright of many, be it the scriptwriter, be it of the musicians, be it of the artist. But when by the mode of assignment, these rights are transferred to the producer for a due consideration. So always the first owner will be the author of the work, and later, if it is being transferred to any other person, then the following person will be the owner of the work. So the first owner will always be the author. Now, how do you decide the authorship and ownership? It's if the work is done in the course of employment. So in contract of service, the employer will have the full control over the work and manner in which it has to be achieved. In case of contract of service, if you are a consultant, then you have the discretion to adopt means for the execution of the work. Now, even in case of government work or pseudonymous work, the owner of the work, even in the case of pseudonymous work, the default owner of the copyright is the publisher of the work, because the identity of the author is not known or disclosed. So till the time it is not disclosed, the default owner of the copyright will be the publisher of the work. Okay. I would like to tell you about this case, V.T. Thomas versus Malayalam Manorama. So you can see it's a 1989 case. So here the V.T. Thomas, he was a cartoonist, and before joining Malayalam Manorama, which is a very prominent daily in Kerala, so he had developed these characters, Bobbin and Molly, and these are the two characters he has said in some interview, like they were his neighbors. So this brother and sister characters, he had created these cartoons, and it was very quite popular. Later, he joined Malayalam Manorama, the publishing house, and continued with these sketches, and it was a huge hit. Now, later point of time, V.T. Thomas decides to resign from Malayalam Manorama and go back to his publication, self-publication. Now, in this case, the Malayalam Manorama had dragged V.T. Thomas to the court, saying that these cartoons belongs to the Malayalam Manorama, so V.T. Thomas does not have any kind of right as an artist to carry out the same kind of the characters in his publication. But the court in this case, even though much of the copyright aspect is not discussed in the case, but the publishing house, the court has decided that you cannot restrain these cartoonists from drawing these cartoons, because these cartoons were developed by the cartoonist before he had joined Malayalam Manorama. So whatever is been the characters which were created during the tenure with the Malayalam Manorama will vest with the Manorama, but the rest which is developed in the course of time later, that will belong to the V.T. Thomas. So even in the course of employment, what is being done, it will belong to the employer. The rest, the employer will not have much say. So these are some of the examples, I would say, for literary work, the novels, poems, the film script, even the computer programs also comes under the literary work. Artistic work is nothing but the painting, drawing, sculpture, cartoon, maps. And interesting part in the Copyright Act is that the section says that irrespective of the artistic quality. So irrespective of the quality of the art, it will be granted copyright protection. Then musical work is nothing but the musical notation without the words. The words are the lyrics. Lyrics will come under the literary works. Dramatic work is the choreographic work for ballet, dance, then the scenic arrangement which is there. If you remember, there was one out-of-court settlement for the Manganya seduction. So there is a scenic arrangement which was copied by another production company for a musical concert, and it was decided out of court, wherein it was a clear kind of infringement of the scenic arrangement which was done for the stage. Cinematographic work is like film, television shows, video games, and sound recording is nothing but the audiobook and the recorded speeches. Now, there are certain things which cannot be copyrighted. For example, as I said, the facts. Then short phrases or the single word that cannot be registered. Then the title of the film that cannot be registered. So there is a case, Krishika Lulla case, wherein the title Desi Boys was not given the copyright protection. The names like Amitabh Bachchan, that cannot be protected under the copyright. Slogans also cannot be protected under the copyright. So what I would say is that these are some of the things which cannot be copyrighted, but it doesn't mean that it cannot be protected at all under the IP. So for example, the slogans can be protected under the trademark. So there are few changes. So everything will not be protected under one category of IP. Like I said, in the artistic work, if you see a collage or a ice sculpture or a sand art, basically we have to see whether the medium is like for more than a transitory duration. So if it is not permanent in nature, even if it is artistic work which is of like which is appreciated by everyone, still in such cases it will not be counted as a work under the copyright. Okay. So assignment is possible in case of copyright. It has to be in writing, even for existing work and even for the future work. For the future work, the assignment will take effect only when the work will come into existence. Now, in the assignment deed, if the period is not mentioned, it is deemed to be 5 years. And the territorial extent, if it is not specified, it will be presumed to be extended to within the India. Now, Section 51 talks about the copyright infringement. If any of the work, any of the exclusive rights which is given to the copyright holder is being used by anybody without the license. Now, even if there is a license which is in existence, if the licensee is going beyond or in contravention to the conditions of the license, then also it will be an infringement. Unauthorized use also will be an infringement. Permitting a place for the communication of the work for a profit, that is also infringement. Here comes the liability of the intermediaries. So you can find a lot of correlation between the IT Act as well as the copyright. Now, infringing copy is defined under Section 2M. So infringing copy is nothing but any copy which is made on any medium by any means without the authorization. Now, the infringement can be either direct, it can be vicarious, it can be contributory in nature. So direct is nothing but you see that exactly it is the same. And there are cases wherein you will find some of the books wherein even the spelling errors are being reproduced in the infringed work. So there is, it will be very easy to find that it's a direct infringement. Now, vicarious infringement is nothing but wherein a person is not preventing the infringement. So he knows that the infringement is happening and he's aware of it, and he is not preventing, and he's taking the benefits from the infringement when it is taking place. Now, contributory is when the other person is also contributing to the illegal activity. There are different ways in which we define the copying. Sometimes it will be a very casual connection. So even a casual connection can be an infringement. We call it as a copying. There are instances wherein you call it as a subconscious copying. And there is another kind of copying, we call it as the substantial kind of copying. Now, I will give you one example. It was like, it's long before, you might be perhaps knowing it. This is the plagiarism of the Opal Mehta and the Sloppy First. So this is the Opal Mehta book is written by Kavya Vishwanathan, I think in 2005, 2006. So, you can find there are a lot of paragraphs which is exactly being lifted. Now, even though it has not reached the court, the Penguin publication, when the author of the Sloppy First approved that many of the paragraphs are like lifted verbatim, the Penguin publication had to take off all the copies which were there in the shelf, and so it's a evidence of plagiarism, wherein without authorization you are lifting it and using it for your own benefit. Now, whenever we talk about the substantial copying, we always take R.G. Anand case, and there are certain principles which are laid down in this case that which we consider, and in every case we consider this the guidelines which are given in this case. So there it says that there is no copyright for the theme or the plot. The similarities which are existing in the because of the idea, if there is any similarity, you cannot term it as an infringement. Now, the spectators or the readers and the viewers' perception about both the works plays a very important role. Now, if the work you find it as identical, but if it is treated differently, then it might not be a copyright infringement. Then the copying which is there, it has to be proved by a cogent and clear evidence. So various tests are being laid out by the courts, and in case of any kind of dispute, if the dispute is regarding the stage play being converted into a film, then and they have made several changes to the expression of the play when they were adapting it into a movie altogether, and they have given a different color to it, then to prove the copying, it will be very more challenging. Now, okay, Section 52 talks about the fair dealing provisions. So every copying without the authorized permission is a infringement. But there are certain provisions which are given under copyright, which says that if you fairly deal with the copyrighted work, then it may not come under the infringement clause. For example, if I'm using any kind of work for personal use, including research, if I'm using any literary work for the criticism or the review purpose, or if I'm using any copyrighted work for reporting the current events or the current affairs, even in the Delhi photocopy case, you will find that whatever the materials which were being distributed to the students, the copyrighted materials which are experts from many of the books, it is termed as something which is being done in the course of instruction. So it cannot be termed as an infringement, but a fair dealing. So fair dealing is possible in case of in the law of copyright. Now, remedies are available. There are three kinds of remedies which are there. One is the civil remedy, injunction, then damages, accounts of profits, delivery and destruction of the infringing copies. And nowadays, the Delhi High Court, Mumbai High Court are granting dynamic injunction. So dynamic injunction is nothing but wherein you find mirror websites, and the infringement happens even after the infringed material is being taken down. So they will come up with another website, another web page. So the dynamic injunction is being granted against all the rogue websites, which the mirror websites which keep on coming. Criminal remedies are also granted. Infringement up to 3 years, but not less than 6 months. Fine may not be less than 50,000, but may extend to 2 lakhs. Then seizure of infringing copies, delivering of the infringing copies to the owner is also remedies available. Administrative remedy, there are a lot of administrative responsibilities which are given to even to the customs authorities for the importation of the infringing copies, prohibition and destruction of the imported goods. And for the customs authorities, if you visit their webpage, there is a series of process which you have to comply with before seeking the help of the customs authorities. So this is what I would like to discuss about the basics of copyright. Now I would be happy to take if any questions are there. Thank you.
Madam, I have a question.
Please.
With regards to assignment of copyrights from one party to another,
Yes.
is registration and fees a mandate, or if it is done maybe on an email correspondence or maybe on a stamp paper of 100 as an agreement is required to be done,
Right.
and if it is notarized, will that amount to sufficient execution of an agreement and transfer of assignment rights?
Yes, but the only thing is that you have to give a certified copy to the Copyright Office.
Thank you, madam.
Yes, thank you.
Are there any further questions?
Ma'am, I have a question. I'm Krishna Rao, working with Dr. Reddy's. Parent applications. The
Right.
description in the parent application is eligible for copyright protection. Is there any case law with respect to that?
Can you be a little elaborate?
Parent application. In
Right.
patent applications, description is there.
Right.
The specification of the patent application.
Correct.
That specification is eligible for patent copyright protection.
Like as such, it is a literary work. It's the expression of the idea, which is being, descriptively mentioned. So it can be registered as a literary work.
Is there any case law, ma'am, on that?
There is no case law as such. I have not come across any kind of case law.
Okay,
The
ma'am, thank you.
pamphlets, be it the pamphlets or the brochure, that is also a literary work which is normally registered. But I have not come across any kind of patent specification which is registered as a under the copyright.
Thank you. Thank you.
Hi, madam. This is Manish. I have a
Yes,
question
Manish.
about, right? So there's a lot of website like Music Match or Lyrics Match kind of thing. They're recreating the lyrics. Is it been protected in copyright law because it's been originally written by some writer?
Right, right. The lyrics are protected under the literary work. So if you see substantial copying of the original literary work, then it is an infringement. But in intellectual property, it is the author who has to take the pain to file for the infringement. So they should be aware about, they should do the due diligence. They should find if their lyrics are being substantially copied or making like minor modification and it's been used in any other kind of way. Then the copyright owner has to take the decision of filing for the infringement.
Thank you, madam. I have one more question. May I?
Yes, yes, please.
Madam, nowadays there are a lot of noise writers and new writers and lyricists and many more creative people who may not be in a process of doing it regularly. It may be a vocation or it may be a kind of a passion that they are following. So those people do not get their literature registered. How would they protect themselves and how would they prove that this is actually their content?
Right, I understand. So like I said, copyright registration is not mandatory. As soon as the work is complete, copyright is vested in the work. Now, I understand there are many people who will not go after, the filing process. So you have to take into consideration few things. So earlier days, we used to say, we used to tell the clients that, at least you send a registered copy of your work to yourself. Now you have the provision of like emailing and documenting your work, and even before you come up with your fair copy, you will be having some of the works which are already there with you. So you try to email it to you and document in such a way that it will be helpful for you in case if you have to fight for infringement. So but the best way I would say is that you have to file for the copyright. So the copyright registration with the Copyright Office gives you more kind of power when you have to deal with such kind of scenarios.
Thank you, ma'am.
Welcome.
Madam, I have a last question. The question
Yes.
is, how would one value or if at all somebody has to file a suit, how would one value its own literature? How would a claim be substantiated before the court of law that the literature that has been copied by somebody, which is in my ownership, how to prove the valuation of the literature?
You mean the economic valuation or the?
Yeah, I mean the economic valuation.
Okay, so economic valuation is nothing but when you have to, when you're filing for any kind of remedy, you have the accounts of profits. So how much loss is incurred by you? Just like in trademarks, if any kind of business, comes up with identical marks or identical goods or service, and there is a dip in your business, then you just have to show the proof relating to how much your business was doing earlier and now how much it is not given in the market. So that valuation has to be made by an IP evaluator. So so such kind of things, when you have all the documents relating to your sales, and you find there is a dip in the sales because of this infringement, that is what you have to prove.
Any further questions from Dr. Samuel? Anyone? Thank you so much, ma'am. Thank you so much
Thank you
for
so much.
enlightening all of us. Yeah.
I just want to add on the last questions on the economics of that.
Sure.
The speaker who has, the audience who has asked the questions, please refer to the book. There is a William Landis and Richard Posner book on the economic structure of IPR. There is a dedicated chapter on the copyright. Okay, so the valuation, the economic structure, how it has been done. Please please refer to that book. You will get the answers in details. Thank you.
Yeah, ma'am, I have one question.
Please.
My name is Supriya. So
Yes.
the thing is that what happens generally, different types of IPs are there. Right now, we are touching base on the copyright exclusively. But in certain fashions, sometimes we face these issues where a particular segment is divided, or rather eligible for different kind of like these IPs. So can I, it's just a general question, can I actually claim under all these at a time, or I have to restrict myself to only one? Since we were like touching base on this monetary and financial issues, so this question cropped in my mind.
Can you just explain it a little bit, because
Okay. Sometimes what happens, like say copyright, it is there. Okay,
Right.
I have a copyright on certain literature, or say computer program, but
Right.
I also have patent on that. I also have a trademark on that. So how can I rather give a valuation to it? As you have rightly stated, that IP valuator will give me the value. But what if I want to claim it under all three segments? Then what? Is it possible?
It is possible, provided that you have to see, like the most of the infringement is is on the literary part of your computer program, or on the the goodwill part of your the business. So you have to evaluate it separately. So under copyright, for the you have the remedies which are given for the copyright categories of your work.
But it is possible to claim under all things, basically.
Under all, in the sense, yes, it is possible.
Okay. That's what I was coming to. I mean, one should not take the precedent over other. So that's what I was coming to. Yeah, great help.
Okay.
Thank you.
Thank you.
Thank you so much, ma'am. Good day.
Dr. Anuma, with your permission, I'll just answer these questions.
Please.
To Supriya. Ms. Supriya, that you are asking for the valuation for the different parts of the same thing, correct? The copyright or the patent.
Absolutely.
Yes, because copyright protects certain things, patent protects certain things, trademark protects certain things. So the valuation can be done separately on that aspect. Correct. So
my question was pertaining to whether I want to. If I want to, I can.
You can. Suppose you have patented a product. For example, I'm giving a patented a product. You have 3-4 patents on that product, and there is some literary work like the logos, which is protected under trademark. But the way the logo has been written, that is copyrighted. So I'm just giving an example. So it separately can be done for all.
Okay, highly appreciate, sir. Yes, thank you.
Yeah, over to Dinesh.
All right. Thank you. Thank you so much, ma'am, for
Thank you, sir. Thank
enlightening
you,
all
sir.
of us. Some of the issues are ever evolving, and you talked about the Berne Convention, and you talked about authorship and ownership, and we have in subsequent um, sessions today coverage about ownership. We are now living in a very interesting world where lot of copyrights will be created by artificial intelligence. If you see chat gpt creating even the books, it's writing poems, it's writing softwares. So who owns it? Who owns that authorship? I can understand the company owning it, but the company gets assigned from the human beings who are authors. So if there is no human being creating that copyrights, this will be an interesting part, and I'm sure that going forward we'll have more sessions on this part about the artificial intelligence and the blockchain with new technologies coming in. Where will the world go finally? So thank you again, ma'am, for enlightening all of us. It's a pleasure to have you.
Thank you,
And
sir. Thank you.
we'll move on to the next speaker, who is Dr. Raghavendra. And before that, I just want to, I see video of Dr. Supran Sen. Welcome, sir.
Thank you very much.
Welcome. Yeah. We all eagerly awaiting your session also. But before that, I will request Dr. Raghavendra if he's around. I did see his icon. If he's around. Dr. Raghavendra, are you there? So maybe I just quick yes. Hello, sir. How are you? So Dr. Raghavendra, we've been known each other from decades actually, and he's always been my I mean, I would like to be like him, Dr. Raghavendra. He's my guru, I would say, in IPRs. And recently, sir actually got again a position in the government of India where he's a senior consultant, and in as a part of DPIIT. And sir, I will leave that part to you. What is your new role, and if you can explain that? But yes, sir has decades of experience. He's been part of Ministry of Law and Justice, Ministry of Commerce and Industry, and he's a civil servant from 1988 batch. He's been a former. He worked in the Registrar of Copyrights also. Uh, and I would actually there's some voice. Can you hear me well? Just, okay. Can you see reflection? Let's see. So, sir, welcome again, and I hope you are able to hear me. I would request Dr. Raghavendra sir to take on his topic, which is he'll be talking about copyrights in cinematography, exploring how copyrights applies to films and cinematic work, protecting your creative content. So,
Sorry to
sir, we are all awaiting your session, and kindly enlighten us with the topic. Thank you so much for joining.
Hare Srinivasa, Vande Matram, and thanks to good morning to all of you, and thanks to Dinesh for inviting me to exchange my views on the most interesting topic in the regime of copyright, that is cinematograph films. And happy to see my friend Supran after a long time. Hope we'll be interacting soon on various platforms as I joined as a senior consultant intellectual property rights in the IP division of the DPI Division of Commerce Industry. I joined about a couple of days back there. Now the DG WIPO, Mr. Darren Chang is coming, and series of activities are there. I understand that most of the stakeholders, including the film community, will be there, so we can meet once again. Coming to the most interesting topic, which I have dealt with in 2012 amendments, beginning with the 2010 bill, copyright amendment bill, which we introduced in the Rajya Sabha. And there are more interesting issues and controversial issues. I will be exchanging my ideas on that, and what proposal we moved, and how the current law reacts to various issues of protection, management, and enforcement. I'll be covering rightly what was left out in the Copyright Amendment Act 2012. Because at the 11th hour, we woke up and tried to introduce few features, protection of cinematograph film, accompanied the piracy accompanied by the technology. Finally that got addressed in the Cinematograph Act amendment, which was approved by the Parliament recently. That is the camcording issues, especially I'm mentioning about. I also touch upon the recent Hollywood strike, where authors and actors and other performers came out openly and they stopped the entire film production for 3 months. So what are the copyright issues associated with films in this day of artificial intelligence, machine learning, and other generative AI issues are coming up? And what happens to the authorship and ownership and all these issues? And if you look at the very question, who is the filmmaker, who is the author of the film? This was settled in the Berne Convention. Those students who are not aware about the Berne Convention, it came into existence in 1886 with the efforts of the famous authors like Victor Hugo and Alexander Dumas. They wanted minimum standards to be introduced, minimum standards in the national legislations which govern the copyright law to be introduced. That's why it started. So how cinematograph film is covered, protected in Berne Convention, and what is the minimum standards, and how India included that, harmonize the international provisions in Indian law. If you look at the Article 14 of the Berne Convention, Article 14 bis of the Berne Convention clearly gives the directions to the national laws how cinematograph film has to be protected. So to the question of author, who is the author of the cinematograph film, as covered at some extent by my previous speaker, Dr. Samuel, that the producer is the author of the film. Why? You may question why. You may compare this authorship with the joint authorship of the EU. All 28 countries of EU, after Brexit, even UK, the Britain, have introduced the joint authorship, which begins with the film director, editor, scriptwriter, music composer, and producer comes at the end. Why in India and US, other countries, producer is there? This issue was deliberated in the Rome Revision in 1928 and the Brussels Revision in 1948, the amendment to the Berne Convention. They decided that it is the matter of legislation of the nations to decide who will be the author. So India decided that the producer will be author. So how producer becomes the author? The definition clearly mentions the section, definitions, interpretation section of the Bayer Act, you see section UU says producer of the cinematograph films. It says in relation to cinematograph film or a sound recording, it says that a person who takes the initiative and responsibility of a making of a film. In making, not only the making here, it is should be interpreted completion of the film and release the film, publishing the film, distributing the film. Earlier used to be in the theaters, now in the digital platforms and also the broadcasting channels. Earlier it used to be wire-based broadcasting. Later satellite came, now direct to home, now all the OTT platforms, any platform, producer is the author that has been recognized. And the reason why they went and recognized they gave a last importance to producer and prime importance to film director, music composer, editor, and scriptwriter, and story writer in EU, because in early 20th century, there was a new wave film started. So in Europe, that trend of new wave percolated to India in 70s and 80s. You are seeing the various people, Satyajit Ray, Mrunal Sen, and other great minds. These are the not only the producers, these are the main directors. They created these new wave films. They communicated the socio-economic, actual living person story in a different sections of people living different part of the country, or this, maybe even the villages and all that. The way they narrated, communicated the story, it is their expression. So EU thought that it is the director who is the key, and who was accompanied and helped by the story writer, script writer, music composer, including editor. These should be the main authors of the film. Whereas we stick to the man who takes the risk, who calls all these people, makes the payment to them, whether it is the actor or other performers, whether it is a story writer, songwriter, music composer, including the film director. Everyone, each and every person who contributes for the making of the film is managed and paid by the producer. He may not be having the money, sufficient funds. He may take bank loans. Thanks to Sushma Swaraj, when she was Information Broadcasting Minister, she recognized film industry, actual industry, so that not the Mumbai underworld will be funding the film. It is the banks, all the financial institutions will be funding the film, giving the loan to make a film. So industry recognition started to make the author of the film get sufficient funds to make a film. Now earlier used to be little amount, now it is going to be the 100 crore film, 300 crore film. Look at the RRR budget, the Bahubali budget, the mind-boggling budgets they are creating, they are investing. And a lot of foreign investment is also happening. Foreign film companies entering into MOU with these film producer and film companies, and a joint venture is happening. Investment, FDI is happening. All this happening after recognition of the film industry as industry in the legal parlance and the Indian policy. So now the entire Indian film industry has become number one, irrespective of the various language, whether Bollywood, Tollywood, all kind of language films are becoming famous. You see the Telugu films, the Bahubali, RRR, or Pushpa, all the famous Telugu films become international, grossing, best profitable films. No Hollywood film compared with the earnings of these films. It is the risk taken by the producer, so producer has to. So what is the film? Now, everyone is talking about the film. Again, what is the cinematograph film? It's beautifully defined in the Act, that is Section 2F. It says cinematograph film means any work of visual recording that includes sound recording, accompanying such visual recording and cinematograph shall be construed, including any work. Look at this, any work. Work means, if you see the definition of the work given in the Copyright Act in Section 2Y, it says literary, dramatic, musical, artistic work, cinematograph film, and sound recording. These are only works. Whereas the performer rights and the broadcasting are not works because there are special rights given to them. They are neighboring rights or related rights of related works. They are based on these original literary artistic works. And basically cinematograph film is an assimilated work. That's why it is called any work which is assimilated and in this and produced by a process which is analogous to cinematography, including video films. Including video films is a cinematograph. You take your mobile, make a half-an-hour video recording. That is regarded as a cinematograph film. So if you look at the definition of video recording, we know the phrase video recording included in the cinematograph. Video recording definition we introduced especially in 2012 amendment to give more clarity, more muzzle to the definition of cinematograph film, so that the producer can exercise his copyright very well to strengthen the economic investment and the creativity of the producer in the form of a film supported with definition introduced for the video recording. It means recording in any medium. It can be digital medium or the recording coming now using various algorithms, machine learning, and neural networks and all that. The generative AI, we call it. By any method, using all these any kind of method, the physical method where you use the typical cinematography film camera or using your mobile or using any hand cam or creating a film using this kind of algorithm machine learning. I'll come to the end of my talk about explaining about its relation with cinematograph film. So, storing, once the film is made, storing it in any electronic means. Okay? There are various means of storing. Now you are going to store this on your computer or your database or in a cloud. Sorry, you create a special cloud where you are going to save it, or blockchain based database you're going to share it. So of moving images, the video recording contains moving images or of a representation of these moving images from which they can be perceived, okay, reproduced and communicated by any method. So how films are communicated? You buy a ticket, go and see a film in a multiplex, okay, theater physically, enjoy the screen, big screen, or sit in your home and access the film through Netflix subscription or Amazon Prime, watch in your drawing room television set, or you watch on your desktop computer, laptop, or your iPad, or any other tab, or your mobile telephone. There are various kind of ways, methods to access, communication to the public and watching happens. So these are the things happening. So videotape is a film or a not? Question came before entertaining enterprise versus state of Tamil Nadu. It's a case of a very old 1984 case. In this, Madras High Court gave a decision that if you see the extended definition of cinematograph films, the court said in its order, the definition of cinematograph film mentioned in section 2F, which clearly includes the process analogous to cinematography. Means it doesn't mean that the Karan Johar engaging the topmost cinematographer, he comes with his team, equipment, whether he's shooting the film in a studio, Eshraj film studio, or outside any location in India or abroad. That is only the filmmaking process, not when Dinesh Motwani ji walking in the street suddenly finds some interesting event happening. He takes out his tab or a mobile telephone, started recording it, and upload this as a film with his commentary. No, that is also film. That's what the court said in 1984 Madras High Court order, that any video film recording which is analogous to making of the cinematography, traditional process of the making film. Videotape, earlier used to be videotape, that has become the absolute technology now. We all have the mobiles. So one may question, the court talked about the videotape, videographing, handy camera. But this is also analogous, making a film using your mobile telephone. So that is important. Okay, you come to know who is the author of the film, that is producer. What is the film you come to know? The cinematograph film, which includes video recording, which may be any analogous. Now, you know that film is going to be released on a Friday, first show, morning 9 o'clock. I want to see the film. What is the publication of the film? Then with this, the term of copyright starts. I'll come to that first. First to understand what is the publication. As explained in the Berne Convention, which has been replicated in the section 3, section 4, and section 5 of the Copyright Act. The publication means if a film made by Karan Johar or Esraj Films, it is released. That is publication. Means making the work available to the public. When you make the work available to the public, not when you preview it. Other day, vaccine war. Well, only small audience, it was a film preview happened. My ex-boss, Amitabh Kant, now the G20 Sherpa, wrote on Twitter, I watched the vaccine war and the actual nitty-gritty is the problem faced by India bringing its own vaccine. People were criticizing, Pfizer is available, aapne kyun nahi liya? Because Pfizer technology is such that Pfizer, for making it, it has to collect 10 APIs from various parts of America. It is assembled only in one company, Pfizer company. Actually, the parts API included, the chemicals and the minerals in that was made in various parts, assembled, and that functions only a minus 70 degrees centigrade, not in the normal temperature, which Covaxin was given to you in any medical center. They just like any medicine they took out from the fridge, they administer you. That is not possible with them, with the Pfizer, and it's very expensive. Indian subtropical conditions, Pfizer can't survive. And a normal syringe was used for the Covaxin, Bharat Biotech Covaxin, our own Atmanirbhar vaccine. Any syringe can be given with that. No. For Pfizer's special syringe, in many countries, lack of the special syringe, Pfizer could not be administered, that died. Why I'm telling all this? First publication again. So I'm trying to compare this. When it is approved by CBFC, certification is given. So group of people are watching there. or group of people watching in the preview, it is not for first publication. Now it happens that before the film is released, if I remember exactly, Supran Senji can correct me, the film Udta Punjab, it made so controversy. Udta Punjab was given CBSE certification. Before film was released on Friday, the film was pirated from the CBSE office. That illegal copy obtained with the watermarking is there. Producer has kept the watermarking on that to protect his copy, digital copy. It was uploaded on the illegal pirated website. Now you say that film supposed to be released, communication, making that available to the public when it is released. Then only it is considered as a publication. On a Friday first show, but 1 week before, already available pirated copy in the various websites is already made available to the public. Is that publication? तो बेचारा प्रोड्यूसर की टर्म खत्म हो गया, term of the copyright. एक हफ्ता, 1 week of the copyright is eaten. The duration of copyright, as per the law, it is 60 years from the date of publication. That is release of the film made available to the public in the film theater, multiplexes. So 1 week has been eaten away because not on the Friday, it was previous week, it has already been released. Maybe 15 days prior to the date, official date of release, publication in the theater, making available to them. What happens to this? No. Any illegal release, that's what the Copyright Act says. For the purposes of this Act, the work published shall be deemed to be first published, notwithstanding it is illegally been, somebody use illegal methods, that is not deemed to be publication. It is written in the section 4. What happens about the simultaneous and publications? Berne Convention talks about the film sometimes release in India on the same day, simultaneously in Europe, in Japan, or US, or any other country where substantial Indian population is there. There it is released. Simultaneous publication. In that day, the same day. Or simultaneous publication considered within the one month, 30 days gap is also there. So in India, it is released this Friday. Within the month, it is released other countries. Or there is a territoriality principle in this, in the copyright. The film can be released in the northern India on one date, southern India on other date, East India other date, within these 30 days, and America someday within 30 days. Then do you think that there will be a different date of publication? No. The same day is applied to all the releases. The territoriality of the copyright. This is the beauty of the copyright. Then comes, if you see the section 13 of the Act, which says, what is copyright? Okay. Section 13 says copyright subsists in what kind of works? It says cinematograph films, copyright subsists. So all producers are happy, movie making companies are happy. Our copyright is guaranteed by the law. But I tell you, one instance, there is a young music composer, a friend of mine, Suparna Senji knows him, Ram Sampath. And you all must be knowing his song, Bag Bag DK Bose, Delhi Belly film, Bag Bag DK Bose became very famous. And after that, he has made very good film, and his wife Sonal is a very good singer, performer. You must have watched her songs on YouTube, and he is growing. Both couple are growing, singing and music. What Ram Sampath had done, he composed music. I'm going to the core part of the cinematograph film. Please try to understand here. Music composer made a music tune for an ad film of the Sony Ericsson. Now Sony and Ericsson both are separated. I'm talking about those days, 2008-9, where Sony and Ericsson were together. Their mobile device was combined trademark name with the Sony Ericsson. That advertisement, 30-second advertisement, was released in all the television channel promoting the Sony Ericsson mobile with the music tune composed by Ram Sampath. And who is the person, the famous actor dancing and promoting this product? That is Hrithik Roshan. This became very popular, very beautiful piece prepared, composed by Ram Sampath. After that, what happened? Hrithik Roshan's father, Rakesh Roshan, was making a film called Crazy 4. Crazy 4 film was supposed to be released. Somehow they thought that to make the film more sellable, let us include item songs in that. So they wanted that one song should be on Shahrukh at the beginning of the film, dancing with the 40 girls. And the same song can be used, another item song in which Hrithik Roshan, you know that Hrithik Roshan is the best dancer. At the end of the film, the same song and the tune, Hrithik Roshan will dance. What is the tune selected? Unknowingly, Hrithik said, Papa or Uncle, Rajesh Roshan, who composed the film music, and this particular item song. I recently acted in a 30-second this thing. Badhiya tune hai, aisa banao na. Unko sunaya. Then uncle did a mistake, Rajesh Roshan. That 30-second music composition he expanded to 3 minutes. Same thing continued. Nothing much adding to it. Song was made, synchronization happened. No? What is the synchronization? When a song is written by Javed Akhtar or Guljar, it is a literary work. On that, in a film is a most beautiful things happen. Sometimes lyric is not written. First producer calls the songwriter, music composer, script writer also sitting in that meeting. The film producer and script writer and director explain to the songwriter and music composer, we want a song in this situation. Situation explained and words explained. Then they will make, the first composer will make the tune. Based on the tune, songwriter will write words. Then song is made. Recorded in a studio where Sonu Nigam, Shreya Ghoshal, Arjit Singh, and Sunidhi Chauhan singing that duet song. Song is made like that. 2 ways. First, songwriter will write a song. Based on those lyrics, music composer will make composition that is relevant or not relevant, or somewhere in the film that is inserted to make the film popular, just like in the Crazy 4, the song has been made item number. Or these people call them and make it. Then question comes, who is the owner of this song? I remember Amir Khan ji was saying that in one of our music and the film industry interaction, Suparna Sen ji was also present in that. Amir Khan ji said, when I made a Lagan film, I call all these people, I give this idea, right? So copyright in the song and music goes to me, not to these people. Then I said, ideas, there is no copyright. You must be, as a film producer, director, you must be feeding them. Taking grace, pains to explain them, Ghana music, aisa banao. Ghana lyrics, aisa likho. But final expression of words is the songwriter. Final composition is the music composer. Copyright in the musical works goes to the author, that is music composer. In the lyric writing words goes to the songwriter, not to the film director or film producer. So if you think that you have better ideas, you can engage a stenographer, dictate them, they will give it to you. and you can become an owner, because anything given dictation, because stenographer writes and exactly the same words you want to write. So copyright is still yours, not the stenographer's. So this is the beauty of the copyright. Finally, the song is made, and film supposed to be released on the Friday. But for the promotion of the films, music company releases this song in advance. It is played on the FM radio or All India radio, or it is released on the YouTube sometimes. And also the various film music channels start playing this. And all this music company makes money, film producer makes money, and all that, including these performing rights societies, copyright and sound recording societies. And Ram Sampath knew that they simply copied and no addition has been done to his music composition. 30-second composition expanded to 3 minutes. He kept quiet. He's a smart guy. On Thursday, film release, to be released on Friday. Thursday morning, he engaged Karanjiwala advocate. The main Karanjiwala sir has passed away recently. The senior Karanjiwala stands in the Mumbai High Court, says that he invokes the section 13, subsection 3 of the Copyright Act. Section 13 is a beautiful section in this. It says copyright shall not subsist. Section 13, subsection 3. So copyright shall not subsist in any cinematograph film if substantial part of the film is an infringement of the copyright in any other work. It says any other work. Composition in the advertisement, Sony Ericsson, Ram Sampath composition is any other work. It has been without permission of the Ram Sampath included in that song. And that song is included in the film. So entire film will not get copyright. That is the beauty of this provision, because you infringe the copyright of other work and pirated that and included in their film. And film will not get a copyright because of that mistake. Court said that when Karanjiwala advocate invoked this section on behalf of Ram Sampath, and then these people, the Roshan brothers, Roshan film collapse. अरे भाई फ्राइडे फिल्म होना है, इतना इन्वेस्टमेंट है फिल्म में, क्या होगा? Court said we are not going to the nitty-gritties of that. Tomorrow film release, you release it, but you cut those item numbers from the film and release it. अरे यार आइटम नंबर बनाने के लिए इतना पैसा डाला हमने, उसके बिना फिल्म कैसा रिलीज होगा? And there was out of court settlement, and a settlement, some amount was agreed and film was finally in advance. That amount was paid to Ram Sampath. In one of my interactions with Ram Sampath, he's a very nice guy, friendly, very frank and low. He won't hide anything. मैंने ऐसे पूछ लिया, अरे यार कितना पैसा मिला out of court? 30-second गाने का चोरी, infringement. He said 2 crores. 2 crores. Bhaiya, all the advocates listening, copyright law students listening, advise your clients. Make this aware of the people. No piracy, no song should be, no clip should be included in the copyright. I go further, what exactly the rights given to the copyright. Section 14 D talks about what are the rights in the cinematograph film. Who will get the rights? Producer. If the film is there, I'm not copying entire film. While watching the film, I take a screenshot of my favorite heroine, favorite hero, or particular scene which relevant to promote my products. Okay, that is infringement of copyright. Or I am monetizing that screenshot as a photo, monetizing commercially. That is infringement. That is reproduction, illegal reproduction without consent and compensation given or taken from the author of the film producer is infringement of copyright. Forget about the entire film uploaded illegally or used on other monetized other platforms. Even a clip, a photograph of the film you can't use. I tell you recently, I'm going to artificial intelligence now. Recently, before artificial intelligence, I tell you the other technology which created problem for these film posters and film photos. During the second wave of the COVID, when Omicron was killing left and right your friends and relatives, I lost 6 of my relatives and best of my two bosses, secretaries of government of India for the COVID. And one person ensured sitting in the ICU of the AIMS that oxygen is made available through the trains from Kashmir to Kanyakumari, from northeast to west. In the government of India, Modi Sahab took a decision that trains will be used for, transporting the oxygen to remotest of the village, which is required to treat the COVID patient. This gentleman of civil servant, himself affected by Omicron, with the oxygen in the ICU, he monitored, made ensure, and he passed away doing that work. And Modi Sahab gave him, with the respect to that civil servant, Guru Prasad Mahapatra. I remember he was secretary DPIIT. He passed away doing this work. He was awarded Padma Shri post. You find this kind of civil servants also. That's why Bharat functions and the government functions. The policy reaches the people. And what I'm saying, during this period, some beautiful minds, lockdown, they were not sitting in the four walls, they're innovating. What they have innovated at the time, disruptive technology, the Bitcoins came. Bitcoins, the fungible tokens, tradable online tokens, currency, which is illegal, not recognized by the government of India and RBI, but still goes on. Many Bollywood actors advertise it. And it is run on blockchain technology. Why it functions on blockchain tech? Blockchain technology came as account ledger, where once you make an entry, you can't delete and put another entry. That is illegal and cheating. So if blockchain is immutable, once you make entry in a block, you can't change it. It is so transparent, and honesty, it can't promote dishonesty. You have to create another blockchain to update that data, update that figures. So there is a chain is more. So it's immutable and not unchangeable. Same thing they use for the functioning of this Bitcoin system. These guys, they have made on the same thing non-fungible tokens. NFT technology of the main. So NFT art they created. They created mostly the Amitabh Bachchan photos and Amitabh Bachchan pictures in which copyright subsists. And there was an online auction of these NFT art photos. Immediately, the right owners, some producer, including Amitabh Bachchan, sent a legal notice to these people. Bhaiya, aap ye nahi kar sakte without taking permission. So it is a derivative work you have created. You may have created a original work, artistic work. Okay, copyright subsists, but the very creation of your work is an adaptive work or a derivative work. With the definition of this being clearly given in the Copyright Act definitions. It is been clearly given what is adaptive rights and adoption. The very first definition of the Copyright Act interpretation is Section 2A is adaptation. In relation to cinematograph, literary work converting into cinematograph work, or artistic work, the conversion into cinematograph work is adaptation. So you can't infringe the right like this. And another important thing of the adaptation, remember me, the famous case of Kapil Chopra versus Kunal Deshmukh and Vishesh Films. What happened? Kapil Chopra wrote a script entitled Zero. And as a script writer, he became member of Scriptwriters Association Registered Society. It's not a copyright society, but it's just like Producers Association, which Supan Sen, Film Producer Association. Supan Sen is the Secretary General. Like that, that private association body under Company Act, Society Act they created. They said all the members whose work, any work is taken, adopted into make a film, the script, should be paid at least 10 lakh rupees. That is the rate they fixed. This guy wrote a film script Zero. Hearing that, the Vishesh Film, Mahesh Bhatt, Mukesh Bhatt brothers and the CEO Kunal Deshmukh looking for the film to a story to make a Jism 2, because Jism 1 was success. They wanted to make Jism 2. He sent a story by email, and 6 months correspondence happened. You know, a kind of perceived contract happened. What is a contract? Offer, acceptance, and compensation. Okay, all these things decided in the emails, and the script was Kapil Chopra film was adapted, and Jism 2 film was made. Jism 2 released in the theaters. बेचारे को अभी तक 10 लाख नहीं मिला. वो समझा अभी फिल्म रिलीज है, मेरा चेक आएगा. But he saw the film. In the credits, his name is not written anywhere. Kapil Chopra का नाम ही नहीं. Then he asked, they stopped responding his emails and telephones. He went to Bombay High Court. 2 judge bench gave a decision. You know, the Justice Shah and Justice Jamdar, 2 Bombay High Court judges wrote the judgment. What is the very first sentence? Very endearing to listen. You know, the words deceit and greed. You know, deceit and greed. On these concepts, most of the Bollywood films are made. But this case starts from deceit and greed because Kapil Chopra was assured of adopting his script Zero into Jism 2. He was not paid the fee for that. And the main credit, script written by Kapil Chopra, titles, that is the moral right, which my previous speaker, Dr. Anama Samuel was explaining, right to attribution, right, the right to paternity, the author's name is a perpetual right, can never be taken away from the work that has not been done. Court decision came, also pay the compensation. The film producer went to Supreme Court, nothing happened. Court said, even Supreme Court said, you have to pay 15 lakh compensation to him. Now film is released. You can't insert the title there, his name, script written by Kapil Chopra. But tomorrow when you release the DVDs, in that his moral right has to be respected, right to paternity. And when you release the film for the broadcasting purposes or OTT, you know, Netflix or Amazon Prime or these things, any other broadcasting, whether you do exclusive license to any television channel or give non-exclusive license to be broadcast in any other television channel, the name has to be inserted in the titles, that script written by Kapil Chopra. This is the power of copyright and films. So these are the things. And coming to the famous attempt we had made in the 2000 bill, because a demand came from the film producers community. Look, EU has extended the term of copyright to life of the author plus 70 years. And America in 1998, USA, they introduced a copyright, Cinematography Copyright Amendment Act 1998, which is famously known as Sony Bono Copyright Amendment Act 1988. And people like you and me, for fun, call it Mickey Mouse Amendment Act, because it all started with the Sony Studios film, Mickey Mouse cartoon film, was entering public domain after completion of copyright term. And Mickey Mouse is so popular. All the cartoon TV channels still they show it, and everyone, even I used to watch it with my son when he was kid. That's my favorite. One of the favorite, Tom and Jerry and Mickey Mouse. He used to watch, and I used to see and enjoy. Those were the days. And term has to be extended. So US government as a policy extended the term for the film companies for 95 years. 95 years. Earlier it was only 75 years. They extended to 95 years. And for authors, they extended to similar to you, life of the author plus 70. So film producers say, why India? Now we are in the midst of copyright amendment. Why don't you introduce this amendment and give it to us? Then we said, no, it may not. It shrinks the public domain and the creativity, and the innovation, and all that. But only we can do it if you agree to the joint ownership, because many film directors also. When you are increasing Indian term, similar to with EU, there is a joint authorship. Film director is the author. Why don't you give it to us? Then instead of so many joint authors, unlike in EU, we said only the intellectual contribution and expression point of view. Director role is more than other people, and other creators are getting their due, whether music composers, songwriters, scriptwriters separately getting their due. They need not be recognized as the author of the film along with the producer. Only film director will get a joint authorship with the producer. All big people like S. Chopra ji was alive, very nice gentleman. We used to have very good meetings with him at that time. Ramesh Shippiji and he and many top producers agreed to it. With that, we introduced the increase of term and the joint authorship of the films in the copyright bill in 2010. But it did not went in good regards of South Indian Film Association people. They came and fought to the end, and the way they fought that, S. Chopra ji and Ramesh Sippy ji dono akele pad gaye. Even entire the Bollywood film producers also started opposing them. There were two groups almost. So the standing committee went with the majority. They said, no, you follow the same old system of producer as the person who take the risk and completes the film. He should be the only author. Then we said, if only producer, we will not give extension. That was settled. So the term extension and joint ownership of author film, that chapter was closed. When the bill was introduced and discussions started after accepting some of the recommendations. Even standing committee in its recommendation said, no, remove this amendment portion from the bill. We removed it, amended it, and all that. That story closed. And then Dinesh, I have some more time, 10 minutes. Yeah, I'll continue.
Yes, sir. Please.
Yeah,
Please,
10
sir,
minutes, and then leave it to the question.
Very enlightening.
I'm taking too long. So now the technology is coming. I'll just jump into the AI technology. You see, the entire Hollywood authors, script writers, including performers, were on strike. Right? They say that the entry of artificial intelligence is harming their earnings, and not only their creativity and contribution, their earnings as well. With especially the emergence of generative AI. So this need to be stopped, and they need a protection in the film industry, especially the Hollywood industry, to survive. Then, then how they are being suffered? If you see, there are two models of artificial intelligence. One is large language models, on which the algorithm like natural language processing algorithm based ChatGPT and Google Bard, Bing, and Microsoft Edge, and these are all work. And there is a generative AI model which is based on machine learning. Both models, what they do, they learn. They're the learning models they create. Based on the learning models, the product output is given to you. So what somebody was mentioning artificial intelligence already writing stories, writing script. Okay, from where it is writing? First, it starts learning from the existing materials. It creates a patterns. It classifies the data available. There is a systematic data and unsystematic data. Systematic data is where titles are available. Certain work is written by Dinesh Motwani. Certain work is written by Supran Senji. The moment you Google, you come to know that. That is systematic data. With the supervised learning method is very easy. It's a supervised method. It starts learning model, classifies the data, categorizes the data. It creates the tokens and then creates the learning models. Then what they are doing, it is not writing the way Dineshji thinks while writing. Supansi thinks writing. That kind of thinking is not happening because their thoughts are coming from their childhood memories, their school memories, where they traveled in the Europe, they traveled in the countryside, they must have seen many people. Those lives, those ideas in the memories, they are read some books. Those are reflected in the stories and dialogues, or making film or writing books. But do you think that artificial intelligence is a human, is a person? No. Now it is a low artificial intelligence model. Tomorrow the high model is coming, already come. People are saying it is sentient. It can feel the touch. हमारे जैसा बुरा भी मान जाएगा, कुछ डांट दिए तो, गाली दे दिए. But all these feelings, it has feelings, good, bad, ugly. It can laugh, smile, cry. Because this kind of sentient feeling, right, you categorize as a human. Arey bhaiya, end of the day, that is a machine. The bloody device. It is an algorithm or a software. It is not a human. It is not a natural person. Why copyright law has come? Very concept of the copyright law, the rights have been given to the creators, the producers, artists, writers, music composers. So there is a theory of incentive theory is applied all over the industrial property rights and copyright and related rights. Why you give incentives? Why copyright is protected? Why you guys enforce the right, civil remedies and criminal remedies? If somebody pirate or somebody sincerely come to you, you give a voluntary license, decide the royalty, take money, because that is giving incentives, because your full-time profession is creating the copyright content. So that your life gives you roti, kapda, makan and some luxury like mobile phone and television car. You can produce more, create more the content. If it is copied and without your authorization, your content, no royalties to you, you are collapse. You are there is an end to you. So that is incentive theory is the backbone of the any intellectual property right, given for natural persons, not for the machine. Machine ये algorithm आया, आज मर गया, दूसरा आ गया. Machine learning से deep learning, neural network, and there's a neural network. It is an advanced thing. Not only unsystematic data, where is a I said systematic data with titles, unsystematic, untitled, and here unsupervised learning happens. Even unsupervised learning can't read and collect the data if a handwritten document is uploaded. Handwritten painting is uploaded, scanned and uploaded. It can't work. Only the deep learning, video vision, that kind of new, technology, artificial intelligence, generative AI, deep learning is coming. Neural vision, only neural vision can read scanned handwritten script or scanned paintings or photographs and all that are not the normal things. So look, how can you compare a natural person with this? This is the technology disruptively innovating, and new things are coming. I'm telling you, after 5 years, what we are fearing, these algorithms may be in the dustbin. By that time, there may be new technology, even you and me may not be conceiving of. Some beautiful mind may be innovating those technologies, changing our life. The platforms may be different. The way you access the contents may be different. Maybe the moment you think, I want to see, vaccine war, immediately on your screen, that film starts streaming for you. Maybe this kind of technology may come. I'm telling you, something already. Tesla has already started experiment the mind to devices in IoT, Internet of Things. With mobile, you manage your TV, your fridge, your lights, your switch, everything. Okay, that you are managing with your device. You can just junk the device and you can start managing with your thoughts. How you are going to align your thoughts, brain with that technology? Maybe you have to wear a device that can get connected with your brain, and what kind of bad effect the vibration effect going to have in the human body and brain, what kind of new diseases you are going to get at that time. I don't know. What I'm saying is, these things, the learning happens the way Javed Akhtar prose or Shakespeare prose or Gurudev Ravindranath prose. These algorithms, they learn. When they write a new thing, you must be thinking that is a new work has been written, new thing. Then what is, no, it doesn't have that capacity to write at right now. They read and learn. What is the learning of algorithm? They learn how these things are written in these situations. About 100 things they learn, they take out, call out the best and they write it. You think that, oh, it is a original expression, original story, original dialogue, and original novel or original non-fiction. That's all. It can't be copyrighted. That's why the US Copyright Office jumped this. And when Columbia University recently, in coordination with US Copyright Office, organized a US Asia Comparative Law Conference of Artificial Intelligence Copyright for 3 days in Waseda University, Tokyo. They especially invited me to give a keynote address and participate discussion. There I explained these things. No copyright should be extended to the humans. What these other composers on the strike in Hollywood, they should be made. These guys have filed a case in US Supreme Court also, that they have to take a consent and compensation. No, bhaiya, there is no need to take your consent and compensation unless and the final product is come out. Because if you see the section 52 1C of the copyright amendments in the fair dealing, we said any device like a desktop or a laptop or your tab or mobile, keeping any transient incidental copy after you do the browsing, because second time you go and browse again, automatically it will come unless your internet connection is good. How it is automatically coming? Because the incidental copying is happening. That copying is not a reproduction for the purposes of copyright. Exception has been given. Right owner can't ask thing. That's what I said. Any learning which artificial intelligence, whether large language models, ChatGPT or generative AI, model like Midjourney or Stable Diffusion, AI apps are doing this work, it is not infringement. अंदर ही हो रहा है ना, बाहर प्रोडक्ट आके commercialize तो नहीं हुआ, so it's not infringement. It can cover up to this, but the moment product is out, you are monetizing. Then question comes, because then what kind of work it is? It is a derivative work or a generative work. It's not a original. It might be original, categorized as the original work. To some extent, the authorship goes to the human, either sitting behind these devices, either giving prompt by text or voice prompt. What is the section 2? Subsection T 6 says any computer generated work. All these are computer generated works. The person behind giving prompts is the author, not the machine, not the OpenAI company or the Google or the Microsoft who providing these algorithms to you. Okay, you are subscribing to them, you're paying the subscribing amount. Okay, that's, and when you are creating, that ownership go to you, not to the machine or the company. Arey bhaiya, otherwise you write a thesis, you write a story, you write an article using a computer, whereas Microsoft Word is there. You subscribe the Microsoft software on your computer, and do you think that what you have typed out, what you have expressed there, entire ownership is going to Microsoft company? No, it's yours. Similarly, so there should not be any confusion. I think I have taken too much time, and if any questions are there, I'm open. Otherwise, Jai Hind, thank you.
Dr. Raghavendra?
Yeah.
Could you hear me?
Yeah, yes, please.
Of course, you are an icon as far as copyright is concerned. So I don't think I mean anything. Anyway, the question is a 60 years period from the date of the publication for a film.
Yeah.
When a film is released and I'm censored, and then it is 60 years.
Yeah.
What do the others? I mean, in a film, you know, there are another 24 cast people are there.
Yes,
so,
yes.
Suppose I is Barsat. Okay. It's already completed. Yes, and I want to make the film. So what happens to the other component like lyrics, etc.? What happens to them?
Lyrics, you're talking about lyrics and
no,
music.
all in the film, whatever is there, dancers.
Okay, it's a collective work. It's a collective work, assimilated work. Yeah, I'm coming to that.
Yeah.
For example, film is released on a Friday.
Okay.
But music is released 2 months back.
Yeah, 90 days normally.
Yeah. 90 days. So
Yeah.
for that publication from the date of release communicated to the public. Music.
For the music.
Yeah, if you're releasing a music video from that date.
Okay, but then I was going through one of your notes, you know, recently I think you have sent me a copyright act. There it said that in case of singing or song, like Albela, you have given an example. If it is for the 60 years from the death, it will be counted, not from the first publication.
No. It is counted from the first publication only.
That is the film, sir. That is the film, Dr. But what about the music? Whichever is there in the film. So that music will be after 60 years after the death of the singer.
Yeah. I'm coming to that.
Yeah.
For example, there is a song.
Albela song.
There is a literary work in the song written, musical work in the music composed. Okay.
Yeah.
Even though film is 60 years, that is included, they won't die because the length of copyright for them is different.
Yes, that's what I'm saying.
Yeah. So as long as the songwriter lives, even after his death 60 years, if 60. Songwriter is dead, his legal heirs will collect from IPRS the rights. Similarly, music composer.
Okay, so 60 years from the death it will be counted.
Yeah. Not the film producer.
I cannot use those songs in the film if I make a film after the publication, 60 years publication, right?
No. They won't lose. That's what the amendment address. Amendment this section 17, 18, 19 says, even we respected the producer right of the film as a one cake or one pizza. There may be other pieces in that. when that film as a whole first published and made available, or a sometimes films are released directly on broadcast TV also, or Netflix also. In this, no separate rights for the other composers. Okay, when these songs are separately exploited as a ringtone during the existence of 60 years copyright in the film, as a ringtone or a callback ringtone or a FM radio or any other platform, they will get 50% royalties. So these 50% royalties, if a film company or a producer is keeping, they have not sold it to the music company.
Okay.
Yeah, yeah. So when film is become super hit, let us say you are paid songwriter 1 lakh rupees for one song. Okay, film has, and now the what is that latest Shah Rukh Khan film which has crossed 1,000 crores. भाई मैं आप इतना कर लिया, मुझे और थोड़ा पैसा दो, मैं ऐसा नहीं था. In Germany there is a bestseller clause. When a book is written, you enter into agreement with the publisher, book publisher. Because you are unknown author, book famous nahi hua, rote rote chal raha hai. But later he has paid you only a minimum number of royalties to you. But book has suddenly become a bestseller, earning humongous amount of money. आपको क्या मिल रहा? Publisher is enjoying. Then bestseller clause says that if a book is earning goes beyond this, publisher has to pay the extra earning this much a percentage royalties to author. Bestseller clause. So already 2012 amendment itna controversial tha, I didn't want to create another controversy introducing that. I kept quiet. Maybe in the future amendment के लिए इसको कबोर्ड में रखा हूँ, cold storage देखते हैं.
Sir, the time will be short. Just one, sir. Is the camcorder been defined anywhere, sir?
Yeah. This definition has been defined in Cinematography Act.
The camcorder is not fully defined.
Yeah, I forgot to mention that. I defined what is camcording and the infringement of the film using this camcording. But it was a later thought because you guys came very late to me after the bill was introduced. When I drafted this in the amendment to the bill, Law Ministry said, no, you can't do it. Once a bill is introduced, any addition has to be made through the Parliamentary Standing Committee recommendations. So you guys were not succeeded in making Parliamentary Standing Committee to give attention to camcording issues. उन्होंने नहीं किया, तो फिर भी मैंने कहा भाई you guys interests have to be protected. I drafted it.
Yes.
But Law Ministry shot down. Even that time, my HRD minister approved it.
Okay.
I could not. Then we left it to, when Cinematograph amendment was coming, then we wrote to them with my draft. Please, we failed to include this. Please, at least, some other window, let us give it to film producer. इसमें करो.
Thank you.
करते उनका 10 साल हुआ.
Thank you, sir. Thank you. Sir, another quick question. Now, is there any court judgment recently that a story doesn't need a license? If I make a film on a established story, it doesn't need a license. Court orders are recently.
No.
So for instance, forget about those even the stories are there. But if I make a film, so
there is a Supransi, I'll just end my talk with this case law. Jagmohan Mundra versus Indian Express newspaper case, very famous. Jagmohan Mundra and Indian Express newspaper case. You can Google it, you will get.
Okay.
In this, the High Court said, Jagmohan Mundra made a film out of a story written in the newspaper. It is already public domain. It's a kind of idea.
Okay.
This not only Indian Express covered this, later it was covered in many newspapers. At the time, internet blogs were not there. Court said, making a film not out of that story is not infringement, but it is not the whole story written in the closed desk and it was offered to the film company and they have not paid, means that is understood. That is adaptation of a story into the film.
No, adaptation is fine.
Just like Chetan Bhagat wrote film 5 Point Someone.
Yeah.
He sold a story for 11 lakhs. Then the script was written by Mr. Joshi. Is an adapted script writer. Similarly, Slumdog Millionaire film was made. It got 8 Oscars. The IFS officer Vikram wrote the book Question and Answer. That story was adapted by Donny Boyle into film called Slumdog Millionaire. He bought the story from Vikram Swaroop. He is retired as one of the secretaries of the External Affairs Ministry, very good diplomat. And he got the money from them. And as a respect to Vikram Swaroop, even though the story did not get the award, when it was adopted into screenplay, it was given one of the Oscars of the 8 Oscars is the best adapted screenplay. Some Britisher wrote the screenplay for the story of the Question and Answer for a Donny Boyle's Slumdog Millionaire. Usko award mila. Fir bhi, Donny Boyle is such a gentleman. He invited for the award function. Vikram Swaroop was sitting there and clapping, sitting next to Donny Boyle when the Oscars were being handed over to all 8 people. Isko to best story ka award nahi mila. Still he was there, but paisa to mila. मगर वो जो open stories ideas है, there is no copyright. If there is a copyright, you have to pay. If there is no copyright,
it is Jagmohan Mundra versus whom, sir?
Indian Express.
Indian Express. Okay.
Sir, if I can just barge in, I know this, sir. You have a wealth of knowledge and the cases and experiences. We are short of a little time today. We'll have one complete day of session with you, sir. I mean, the kind of knowledge that you shared today. And
even one day is not enough, sir. Yeah. One day is not enough.
One day. That is an encyclopedia.
I mean, attend the WIPO conferences. I know that what a wonderful presentation he used to make in all WIPO conferences. Whether it is building, whether it is Marrakesh, whether it is Geneva, he has been making such a wonderful presentation. We need more than one day.
Thank you so much again. Thank you so much again, sir. I wish we had more time with us, and it's becoming more and more as it goes by. And what we will do perhaps is, if there are follow-up questions, I'll write you in an email, and we can share it with us. I'm sure there will be many questions and debates that need to be addressed now.
Thank you, Dinesh. I take permission from you. Thanks a lot. Thank you, Supanji, and all the participants. See you once again.
Come to Delhi and meet you, sir.
Sure.
Thank you, sir. Yeah. All right, we have our next distinguished speaker, Mr. Amit Dev, and I would request Amit ji to talk about his, he's the president of Digi Valley AI Group, and I'm sure that some of the things that Dr. Raghavendra talked about, perhaps you can elaborate more from AI perspective. Because we are again, we overshot the time, I would request Amit ji to spend 20-25 minutes so that if there are follow-up questions, we can take up there. And we'll try to be on time again. Thank you, Amit ji, for your... I can't see you, Amit ji. Amit there?
My camera and audio are both on. You can't see me?
No, we cannot.
I can see you.
You can? Okay.
Sir, Dineshji, I can see him.
Oh, yes, yes. Now I can see. Yes.
Yeah.
Yes.
So, namaskar.
Come to this other side. In the middle, you come.
I am so happy to join you all after about 41 years of my long career, in which I never had the opportunity to interact with your NasCap. But I just would like to say that in 1982, my first job was a trainee at the color TV transmission during Asian Games. And from there till 90s, I was in different small jobs. In 91, I had my life's first break of setting up India's first satellite TV channel called ATN. It was a year before Z, and 2 years later, we also launched Sun TV, which was a great success. But my channel journey continued till I was general manager in Walt Disney's ESPN channel, then Sahara TV, and launched a bunch of Sahara TV channels till 99. From 2000 to 2010, I was mostly involved with telecom convergence of bringing content over the telecom carriers, IPTV and other models, mobile TV. But from 2012, my journey was devoted to artificial